Good afternoon, everyone. Welcome to this lecture series on the law on obligation and contracts. This afternoon, we will be discussing on some of the remaining defective contracts. We will start with voidable contracts. So let me share my screen with you. Okay, voidable contracts, chapter 7. Under Article 1390, voidable or annullable contracts refers to a valid contract, but one of the contracting parties is incapable of giving consent. Or even if the contract is valid, the consent of one of the contracting parties is suffering from vitiation of consent. It can be in the form of a fraud, intimidation, violence, undue influence, or mistake. I actually have an acronym for this one. So when you say voidable contract, this can be FIVUM or FIVUM. F stands for fraud, I stands for intimidation, V stands for violence, U stands for undue influence, and M stands for mistake. Now, when you say annulment of contract, this is a remedy provided by law for the declaration of the inefficacy of a contract based on a defect or vice of consent in order to restore them to their original position as when the contract was executed. Now, under Article 1391, there are different vices or defect of consent, intimidation, violence, undue influence, mistake, or when the party to a contract is a minor or other incapacitated person. Now, you have to observe the beginning period of the running of the prescriptive period for filing an annulment of voidable contract. Now, the prescriptive period in intimidation, violence, or undue influence will commence to run when the defect ceases, meaning to say, when intimidation, violence, or undue influence ceases to exist, then the prescriptive period will commence to run. On the other hand, when it comes to mistake or fraud, the running of the prescriptive period is from the time of discovery. Now, when it comes to minors and other incapacitated persons, the commencement of the prescriptive period will be pegged on the time that the guardianship ceases to exist. Now, in voidable contract, there is what you call as ratification. A ratification is where one voluntarily adopts or approves some defective or unauthorized contract or act without his approval or consent would not be binding on him. So in other words, class, when you say ratification, previously there was no consent given by a party. But when a party ratifies the contract, he voluntarily adopts or approves the unauthorized act or contract, and that approval of the unauthorized contract will bind the party so ratifying. Now, ratification, in other words, will cleanse the contract from all its defects from the moment it was constituted. Under Article 1393, there are two kinds of ratification. First is express, when the ratification is manifested in words or in writing, or implied, when ratification can take in diverse form, meaning it has not been categorically stated, no, but is implied from the statement or implied from the conduct of the party. So when you say diverse form of implied ratification, these can refer to silence or acquiescence by acts showing adoption or adaptation rather, or approval of the contract, or by acceptance and retention of benefits flowing therefrom. So when, for example, a party did not give his consent to a contract, that contract is voidable. But if later on that particular party would accept the benefits arising from the contract, meaning there was acceptance and in fact retention of the benefits flowing from the contract, then that party is deemed impliedly ratified, no? Or that party must have been impliedly ratified the voidable contract. In other words, class, when there is when a party will receive, no, any monetary benefit flowing from the contract, then that act of acceptance from that party is an act of implied ratification. Now, under Article 1393, there are requisites of implied ratification. Number one, there must be knowledge of the reason which renders the contract voidable. Two, such reason must have ceased. And three, the injured party must have executed an act which implies waiver. So in implied ratification, okay, the first requisite is that the person ratifying must have knowledge of the reason which renders the contract voidable. No? There is no such thing as ratification if the party so ratifying is not aware of the ground which makes the contract voidable. So before there can be implied ratification, that party must be aware of the ground which makes the contract voidable. Otherwise, if he is unaware of such ground which makes the contract voidable, then there can be no implied ratification. In other words, class, implied ratification can only be done knowingly and intelligently. Now, number two, such reason must have ceased and the injured party must have executed an act which implies waiver. Now, express ratification has the same requisites except that it is effected expressly or categorically. Now, the question is, who may ratify a contract entered into by an incapacitated person? So, for example, if a person is a minor child, then that makes the contract as voidable. Now, how can the minor child ratify a rather voidable contract? Can the minor child himself ratify the contract? Answer, no. It must be ratified by the minor child's guardian or the injured party himself, provided that he is already capacitated. Meaning, the minor, upon reaching the age of majority, can ratify a voidable contract. Now, under Article 1395, the consent or conformity of the guilty party to the ratification is not required. In other words, class, for example, a contract is entered between A and B. A is a minor and B is of legal age. Now, if A's guardian will ratify the contract, or A, upon reaching the age of majority, will ratify the contract, question, is the conformity of B, the party who is not suffering from any inability, or who is not suffering from any incapacity, no? Is the consent of such person required? The answer is no. The consent or conformity of the guilty party to ratification is not required. The reason for this is that ratification is unilateral. Now, what are the effect, or what is the effect of ratification? If a voidable contract is ratified, no, there is a retroactive effect of ratification. What is retroactive? Retroactive makes the contract valid from its inception, subject to the prior rights of third persons. So if a voidable contract is ratified, the defect in the contract is cured from the beginning or retroactively. No? Okay. Now, what are the requisites in order to bring an action for annulment of a voidable contract? First, the plaintiff must have an interest in the contract. Second, the victim must assert the same. No? Okay. So these are the requisites of an action for annulment of contract. No? The plaintiff must have an interest in the contract and that the aggrieved party must assert the same. So there are only two requisites. Okay. Now, under Article 1397, can a third person, meaning a person who is not a party to the contract, challenge the validity of the contract by filing an annulment of contract? For example, a contract between a minor child, and B was entered into. Now, C is not the legal guardian of A, but only a concerned friend, for example. Now, as a concerned friend, C would want to annul the contract because A is voidable, and because he is a minor, he can be easily deceived by B in his perception. Now, question, can C, the friend of A, file a complaint for annulment of contract? Answer, no. Under Article 1397 class, a third person or a person who is not a party to a contract has no legal capacity to challenge the validity of a contract. No, tandaan niyan, class. Only the aggrieved party, meaning the minor child, or the party who suffers from an incapacity, or his guardian can file an action for annulment of contract, no? Annulment of a voidable contract. So for example, if a party suffers from intimidation or violence, only that person can file an action for annulment of contract. Not a third person or a friend or a distant relative or any person outside the contracting parties has no legal capacity to file the action for annulment of a voidable contract. Now, since, for example, B is the guilty party, no, the guilty party would refer to the party who does not suffer from any incapacity. Now, for example, what if the minor child is not willing to file an action for annulment of contract? Can the guilty party file for annulment of contract? In other words, can the party who does not have an incapacity take to himself the option of filing a complaint? The answer is no. Because of the principle that he who comes to court must come with clean hands. This is actually an old adage or saying in court. He who comes to court must come with clean hands. If a party is guilty of some offense, then he cannot be expected later on to coming to court because he has an unclean hands. So there, the guilty party class may not file an action for annulment of contract, also a third person. Let us go to Article 1398. Now, as a general rule class, if the contract is annulled, the parties must restore to each other what they have received from the contract. Okay? Now, if the obligation is real, then how do you perform mutual restitution? Now, you will have to return the subject matter with fruits or the price with legal interest if returning the subject matter is no longer feasible. So it's either you return the same object with fruits or you return the price of the object if the object is if the return of the object rather is no longer feasible. Now, on the other hand, if the obligation is personal in nature, then you can return the value of the service or the amount of the service, no, is the basis for damages. Now, as a general rule, if the contract is annulled, then the parties must restore to each other. Is there an exception? Yes. An incapacitated person is not obliged to restore what he has received unless he benefited from it. Although the other contracting party is still bound to return what he had received, whether he benefited or not. So an exception to the rule of mutual restitution is an incapacitated person. When in cases of an incapacitated person, he is not obliged to return what he had received. And then exception to the exception is when the incapacitated person has benefited from what he have received, then there is an obligation to mutual restitution. But the other party or the guilty party is bound to return what he had received, whether he benefited or not. Okay. Now, under Article 1400, what is the effect of the loss of the thing without the fault of the debtor or with the fault of the debtor? So you remember that loss of the thing without the fault of the debtor will extinguish the obligation. On the other hand, if the loss of the thing is with the fault of the debtor, then the debtor is liable to pay indemnity for damages plus fruits and interest. Now, there are different circumstances when the action for annulment is extinguished. Number one, if the thing is lost through the plaintiff's fault or fraud. Two, right of action is based upon incapacity of one of the contracting parties. Okay, so when a contract is annulled, reciprocal obligation of restitution is created. But there will be no annulment if a party cannot restore what he is bound to return, even if loss is due to a fortuitous event. So class, even if a ground for voidable contract exists, if a party is not in a position to return what he had received or to restore what he is bound to return, then he cannot avail of annulment of contract. So this will end our discussion about voidable contract. We will now go to another defective contract. Chapter 8, Unenforceable Contract. We start with Article 1403. Class, please memorize Article 1403. This is a long paragraph, but I hope you memorize the same. Now, what is an unenforceable contract? An unenforceable contract is a contract which may not be enforced from its term, or it cannot be given effect in a court of law, or a party may not sue on an unenforceable contract by reason of certain defects provided by law until and unless that they are ratified. Now, there are two kinds of unenforceable contracts. Or rather, there are three, no? The first paragraph, the second paragraph, and the third paragraph. Now, under the first paragraph, those entered into the name of another by one without authority of another, or what we call as an authorized contract. This is the first kind of unenforceable contract. And the second kind is those that do not comply with the statute of frauds. Now, what is a statute of fraud? We will discuss it later on. And then third, where both parties are incapable of giving consent. So under these three instances, all of them are unenforceable contract. First, an authorized contract. Second, those that do not comply with statute of frauds. And third, where both parties are incapable of giving consent. Let us go to statute of fraud. Statute of frauds class is enacted only to prevent fraud, but also to guard against the mistake of honest men by requiring that certain agreement must be in writing. So class, ang objective ng statute of fraud ay para hindi magkaroon ng pangloloko o ng pagkakamali patungkol doon sa usapan kung ano ang dapat gawin. So the statute of frauds class is enacted to prevent fraud or mistake, so that the law will require that certain agreements must be reduced in writing. Okay, so there are fundamental principles of statute of fraud. Number one, it is not applicable in actions which are neither for damages because of a violation of contract. Second, this is the most important fundamental principle of statute of fraud class. Statute of fraud is applicable only to completely executory contract. Tandaan nyo yan. Marami nagkakamali dyan. Yung iba kasi, minimemorize nila ang statute of fraud, and then pag nakita nila yung ground na yon, sasabihin nila agad, unenforceable contract. Because it violated the statute of fraud. Tandaan nyo, class, statute of fraud is applicable only to completely executory contract. Ano ba yung tinatawag nating completely executory contract? There are two kinds of contract according to its stage or performance. Executory contract and executed contract. Executory contract is a contract in preparation of another contract. If the contract has been accomplished or executed, or performed, then it is executed contract. Now, class, for example, merong contract of sale, okay? And then the contract of sale is for the purchase of a personal property in the amount of 10,000 pesos. And then there is no agreement in writing, okay? So sabi ng statute of fraud, sale of personal property, no, kailangan must be in writing. If it is what? More than 500 pesos. Now, tanong, for example, there is a contract of sale of personal property for 10,000 pesos, and then class, wala silang agreement in writing. Now, nagbilihan sila, binayaran na ng buyer yung item, and then sabi ng seller, teka, hindi ko pa pwedeng i-deliver sa'yo yung item because this contract is actually unenforceable. Is that contention correct? Answer, no. No, class. Class, statute of fraud applies only to completely executory contract. Now, when there is a performance by one party, or by both parties, then the contract ceases to be executory. It becomes an executed contract. So if there is a partial performance or complete performance, then do not apply the rules on statute of fraud. Third fundamental principle of statute of fraud, it is not applicable where the contract is admitted expressly or impliedly by the failure to deny specifically its existence. It is not applicable where a writing does express the true nature of the agreement. And 5, does not declare that the contract is void but merely unenforceable. And 6, the defense of statute of fraud may be waived for failure of timely invocation. And then 7, defense of statute of fraud is personal to the parties and cannot be interposed by strangers to the contract. So what are agreements within the scope of statute of frauds? So lahat ng i-enumerate sa screen class, these are the agreements or transactions which will fall within the scope of statute of frauds. In other words, they are required to be reduced to or reduced in writing. Agreement not to be performed within 1 year from the making thereof. Class, i-memorize niyan, ha? Okay. Now, number 2, promise to answer for the debt, default, or miscarriage of another. Third, agreement in consideration of marriage other than mutual promise to marry. Fourth, agreement for sale of goods at price not less than 500 pesos. Okay. So class, tandaan nyo yan, na not less than 500 pesos. Hindi bababa ng 500 pesos. Kailangan in writing na siya. Paano kung eksaktong 500 pesos? It must be in writing. Kasi ang sabi ng batas, not less than 500 pesos. So 500 pesos and above, sale of goods kailangan in writing. Ha? Tandaan nyo. Now, 5, agreement for leasing for a longer period than 1 year. So upa for more than 1 year must be in writing before it becomes enforceable. Agreement for the sale of real property or of an interest therein, and representation as to the credit of a third person. Memorize all of these 7 enumerations. Memorize. Okay. Now, what are the modes of ratification of a statute of fraud? Now, a statute of fraud is ratified by failure to object to the presentation of oral evidence to prove the contract. Second, by acceptance of benefits under the contract. So class, tandaan nyo, yung statute of fraud, pwede yang ma-waive. Pag nag-present ng oral evidence, meaning testimonial evidence, hindi documentary evidence, dapat mag-object ka. No? If you fail to object to the presentation of an oral evidence or a testimonial evidence to prove the contract, then you are waiving your benefit under the statute of fraud. You have to timely interpose an objection, otherwise your right under the statute of fraud will be waived. Now, if you have accepted benefits under the contract, you also ratify the statute of fraud. Now, let us go to the oral sale of real property. A party to an oral sale of real property can now compel the other to put the contract in a public document for purpose of registration. This is the right of one party to have the other execute a public document which is not available in a donation of real property when it is in a private instrument, because the donation is void when it is not reduced into a public document. Okay. Now, the third kind of unenforceable contract is when both parties are incapable of giving consent. No? Both parties are incapable of giving consent. I always ask this to my students. What if one party is incapable of consent? What is the status of contract? Answer, voidable. Tandaan nyo yan, class. One party incapable of giving consent, status of the contract, voidable. What if both parties are incapable of giving consent? What is the status of the contract? Answer, unenforceable. Yan ang trick dyan, class. Do not forget. This is the third kind of an unenforceable contract. Okay. However, if the parent or guardian, as the case may be, of either party ratifies the contract, it becomes voidable. If the ratification is made by both parties, the contract is then valid. Now, in the same way, kanina sabi natin, pag voidable ang contract, hindi pwedeng i-file ng third person yung action for annulment of contract. Now, that's the same principle applies to unenforceable contract. A third person cannot question the unenforceability of the contract, since the benefit of a statute of fraud can only be claimed by the party to the oral contract. Now, it is a personal defense. Okay. Now, next meeting, we will discuss about void or inexistent contract and the remaining provisions on the law on obligation and contracts. So we end here. Thank you for listening and see you again to our next meeting. Thank you.